as expansive. Congress can tax as it will, and it's not hemmed in by. How could anyone think that health insurance doesn't involve commerce? Think of the criticism today of the Health Care Act. It is said in some quarters that this will be the ruination of small business. Well, small business is commerce, right? It is very difficult to understand how that cutback on the reach of the Commerce Clause came about, and I think it will not have staying power.
What do you mean? Will it be overturned?
That view, yes. And we will get back where we were ever since the late 30s, when economic and social legislation is recognized as the proper domain of the Congress, and that is, as devoted as you may be to your particular state, there are so many things in this highly industrialized world that states can't do, that have to have a national solution.
That point about the national solution was another example of you being a good originalist, because you said that the framers of the Constitution were concerned about the collective action problems in the Articles of Confederation and wanted to empower Congress to act when the states were powerless to coordinate their actions together.
Yeah.
So you do believe the commerce reading will be overturned eventually. Are you concerned in the short term that it might lead to the invalidation of other economic legislation, environmental laws, health and safety laws, and so forth?
I'm hopeful that it will not have that. It will not have that ramification. All of the precedent except this healthcare is the other way.
Let me ask now, I mean, this was the most remarkable term, but about the marriage equality cases, about the Defense of Marriage Act case and the Perry case. In the DOMA case, you found that there was standing to hear the case, and in the Perry case that there was not standing. What was the difference between the two?
There was standing in both cases originally. In the Defense of Marriage Act case, I think you know the background of the case that the court decided. These were two people who lived together in a grand partnership, and one of them was dying and wanted to have the official blessings of government on this union, so they married in Canada and then came back to New York, which recognizes gay marriage and recognized the Canadian marriage. And then the one partner died, and the other gets something like a $360,000 estate tax bill from the government. She would have no bill at all. If her marriage were recognized, she would get the marital deduction. So that was the DOMA case. Originally, the government was defending the law, as it ordinarily does, but then it decided, after the case was heard in the court of first instance, that the plaintiff was right and the law was indeed unconstitutional. So one would think that would render the case moot, except that although the government switched sides in its view of what the Constitution required, it didn't give the surviving spouse her refund. So as long as the government was holding the money, there was a continuing case or controversy. And that's what the court, it was on that basis that the court said, yes, we can hear the case. It's still a live case or controversy. She hasn't gotten the refund. And if you're concerned about, will the court be given the best arguments on both sides? Well, surely that was so. I think we had over 100 friend of the court briefs in the DOMA case. So everyone, and we were very well informed of everyone's views by this. So you had the adversary presentations, and you had a controversy that was not yet over.
I was in the courtroom for the DOMA case and remember that remarkable moment when Justice Kagan read from the congressional report, and one of the sponsors had stood up and said, the purpose of this law is to express moral disapproval of gays and lesbians. There was a gasp in the courtroom, but it seemed, was the case over from that moment? Because the court has said that moral disapproval is not a legitimate basis for laws under even relaxed scrutiny.
Yeah, well, some people, as you know, say we should look at the text of the laws that Congress passed, and we should not pay any attention at all to so-called legislative history, what they say on the floor, even what they say in committee reports. So that kind of statement, which was startling, that this was an expression of moral disapproval, that would have no influence on someone who doesn't look at legislative history.
Now, that some people who don't like legislative history includes most prominently Justice Scalia, of course. And you had called Justice Scalia to task for having objected to judicial activism in the Defense of Marriage Act case, but not been reluctant to strike down an act of Congress in the Voting Rights Act case.
Yes. But even without the legislative history, when there was reams of legislative history showing the continuing need for the Voting Rights Act.
So perhaps that's the answer to my question about what's the difference between these cases. The Defense of Marriage Act case is one case where you did vote to invalidate an act of Congress, which you earlier defined as judicial activism. Why was it okay to strike down the Defense of Marriage Act, but not the Voting Rights Act?
Because the Defense of Marriage Act was Congress violating the equality and liberty guarantees. That fell in what I could call Justice Stone's first category. The court has to be careful to see that Congress is not treading on our most fundamental human values. And the court, DOMA wasn't the first time the court encountered this question. It wasn't so long ago that many states made consensual sodomy a crime. And in the Lawrence, and the court at first in Bowers against Hardwick said, that's okay. It's okay to express moral disapproval of that kind of activity. And then the court turned around in the Lawrence case and said, the state has no business intruding on the lives of people who are doing something that doesn't harm anyone. So that was Lawrence. And then there was the Colorado ordinance case after that. So the court had already, the themes that were expressed in DOMA had already been stated.
And there was also, of course, the Virginia Military Institute case, which you wrote so eloquently, that said that preserving tradition for its own sake is also not a legitimate purpose. So that sort of knocked out the main reasons that people had for opposing same-sex marriage and made the case perhaps easier for the challengers. You famously argued, I think persuasively argued, that the court overreached in Roe v. Wade, that it read too broadly the privacy guarantees, and if it had merely struck down the extreme Texas law at issue in the case and not settled abortion for the whole nation, it might have avoided the backlash that ended up harming abortion rights. What is the difference between marriage equality and abortion? Why was the court not jumping ahead of public opinion in this case in a way that you think it did do in Roe versus Wade?
The court is a reactive institution. You react to the controversies that are brought to the court. In Doma, it was a couple claiming that their marriage had the same right to be recognized by government as anyone else's. So the only way that case could be resolved is by saying DOMA, that says these people will be treated by the federal government as not married, is unconstitutional. Roe v. Wade, I should be very clear, I think the result was absolutely right. Texas had the most extreme law in the nation. A woman could not get an abortion unless it was necessary to save her life. It didn't matter that she would be left infirm. Whether the conception was the result of rape or incest, none of that mattered. The court could have decided the case before it, which is how the court usually operates. It should have said that law, Texas law, is unconstitutional. It didn't. There was no need to declare every law in the country addressing abortion, even the most liberal, unconstitutional. That's not the way the court usually operates. It doesn't take giant steps. So my notion was that this was an issue that was in flux all over the country. In state legislatures, sometimes the women were winning, sometimes they were losing. They were getting political experience, which was a good organizing tool. And then the Supreme Court said, you won. And it also gives the opposition one single target to hit at. If you have to disperse or diffuse your energies fighting this issue in Ohio and in California, that's one thing. But if you have one target, Roe v. Wade, announced by the unelected life-tenured judges, that's a very good organizing tool on the other side. Now, I know many people think that my judgment about that is wrong. I know that there was a very strong right to life movement long before Roe came down. It continued after. But I think that there is no response to the presence of a target that was simply not there before Roe v. Wade. If the court had responded to the Texas law and put down its pen, it's like there was a criticism of Roe by a great constitutional law scholar, Paul Freund. And he says it's about the little boy who's trotted out at a family party and asked, do you know how to spell banana? And he said, yes, but I don't know where it stops. So and also the other aspect of my criticism, the image you get from reading the Roe v. Wade opinion is it's mostly a doctor's rights case, a doctor's right to prescribe what he thinks his patient needs. I mean, the images of the doctor and the little woman that is being, it's never the woman alone, it's always the woman in consultation with her doctor. My idea of how choice should have developed was not the not a privacy notion, not a doctor's right notion, but a woman's right to control her own destiny, to be able to make choices without the big brother state telling her what she can and cannot do.
That has been your great contribution to the jurisprudence of gender equality. Will the court, do you think, eventually someday recognize abortion rights as a question involving gender discrimination?
But I think there's that theme already in the Casey decision. This is when the court had an opportunity to overturn Roe v. Wade. It said no, it's precedent. A whole generation has grown up understanding, girls have grown up understanding that if they need it, it will be available to them. So, in that Casey decision, there is a healthy infusion of the woman's, that this is got to be the woman's choice.
And yet, of course, in the Stenberg decision, the partial birth abortion decision, that rhetoric took a rather different form, and you objected in your dissent that the majority was being paternalistic in imagining that women needed protection from their own choices. They might have regret their choices and have second thoughts, and therefore they had to be protected.
Yes, the woman had to be protected from her own misjudgment, that she would in time understand she had made a dreadful mistake. But adults make mistakes. They're adults and they're entitled to make judgments for themselves.
You're not a fan of paternalistic stereotypes about women, no?
No, and I like what Justice Brennan in one of the early gender discrimination cases in Frontiero, and he described this pedestal that many of us have thought women are on, in reality, too often turns out to be a cage. So.
And when you litigated those cases, you faced male judges who had many of those stereotypical views and decided, therefore, to represent male plaintiffs because you thought that they could better empathize with guys like them.
Well, I had at least as many, more women plaintiffs than men plaintiffs. We were trying to educate the court that pigeonholing people because they are a woman or because they are a man, to say men can be doctor, lawyer, Indian chief, but girls can keep the house clean and take care of the children. That there's something wrong with that view of the world. The man's world with a little space in it for woman in her own corner. The notion was, don't stereotype people because they are male or because they are female. Recognizing that the stereotype might well be true for the vast majority of people, but there are people who didn't fit the mold, and they should be allowed to make choices, to live their lives without being pigeonholed because of their sex. That's why I think the Stephen Weisenfeld case, which was the first, quote, men's rights case the Supreme Court decided, was such an excellent example. This was a man whose wife was a teacher. She had a very healthy pregnancy. She was in the classroom till the 9th month. She went to the hospital to give birth, and the doctor tells Stephen, the father, you have a healthy baby boy, but your wife died of an embolism. And Stephen Weisenfeld vowed that he would work only part-time till his son was in school. full-time. So he applied for the Social Security benefits that he thought were available when a wage earner dies and leaves a child in the care of the surviving parent. He went to his Social Security office, and they said, sorry, Mr. Weisenfeld, that benefit is a mother's benefit. And you are not a mother. My wife paid the same Social Security taxes that other people pay. The idea was the woman paid her Social Security taxes. The government did not extend to her family the same protection it would extend to a man's family. The man doesn't have the choice to be a caregiving parent. He doesn't get any help when his life partner has died. So it was the idea that men don't take care of children, and women are not real wage earners. They are at most pin money earners. That's what we were trying to, and it was, the judgment was unanimous. It was the only time my dear old chief ever voted for the side that I was advocating. And the court split three ways. Most of them thought this discrimination is really against the woman as wage earner. Some thought it was discrimination against the father as parent, and one thought it was discrimination against the baby. And that was then Justice Rehnquist. He said it's totally arbitrary that a child should have the opportunity for the care of a sole surviving parent if the parent is female, but not if the parent is male.
Well, these questions are central to gender equality, and you have, or did a few years ago, a picture in your chambers along these lines. I think your granddaughter Clara is here tonight, and the picture, is it of Clara's father holding one of his children?
It's Paul. Clara knows the picture. Well, her mother took the picture. It's Paul when he was 2 months old. He's on a bed with his father, and Baba was looking at Paul with such tremendous love. And so that's my idea. A child should have two caring parents. And if every